A lot of landlords have issues, and so do tenants, when it comes to the landlord wanting to enter the property. In a lot of cases, tenants are just flat out denying access to the property. What are you to do if you have an absolute need to enter, but your tenant won't allow you? Today we're talking all about a landlord's right to enter rental property. Let's get started. So like with many parts of effective property management, it's important for landlords to be able to discuss the issue of entering the property with their tenant well in advance of ever having to enter the property. Many tenants are extremely apprehensive about the idea of the landlord coming in once the tenancy has begun. Many tenants believe that a landlord is not allowed to or has no right to enter, and that generally just isn't the case. In order for you to gauge where this tenant is on the issue of you as a landlord entering the property at certain times during the tenancy, it's really important to have that conversation before you ever hand over the keys. And you may be asking, well, Ernie, why is this at all necessary? Well, because it's recommended, definitely by me, that you enter into the property at least twice during the leasehold. By making it clear to the tenant that you intend to enter the property, even on a non-emergency basis, you're at least going to open the conversation up. And if you have a tenant who absolutely refuses, who tells you before the lease ever begins, no, I'm sorry, I don't feel comfortable with that, or I will not allow that, then that's an appropriate time for you to back out of that deal. You haven't signed the lease, you haven't exchanged money, you haven't given the keys over. That's a great indication that this is not an appropriate fit. Now, certainly in order for you to have an effective conversation, you need to know what your rights are. What will your state allow in terms of your right to enter? The state of Texas will allow a landlord to enter property so long as the basis for entry is a reasonable one, so long as the time that the landlord intends to enter is reasonable, and so long as the landlord enters in a peaceful manner. Now, generally speaking, we also want to look at a written lease. When a lease is silent or completely verbal, this gets kind of complicated because it's hard to gauge precisely what is reasonable when the parties haven't really discussed the landlord's right to enter. However, if your lease clearly establishes a right, and many good leases do, if your lease clearly establishes your right to enter the property, that's a presumption of reasonableness as long as you follow whatever the guidelines are in that document. Does your lease require you to give written notice? Have you given that written notice? If so, then you are presumed to have a reasonable basis, and if you enter in a peaceful manner, you should be okay. You know, the rules and the limits are going to vary to some degree, across the country, but this is generally the accepted practice for landlords across the U.S. How much written notice do you have to give? In what manner do you have to deliver written notice? Again, those rules are going to vary, and also within, for example, the state of Texas, different leases are going to require different things. In certain circumstances, written notice will absolutely be required. In others, it simply will not. So take a look at what your lease says and how your lease allows you, combined with what state law already allows you to do as a landlord, so that you know how to explain this when your tenant asks. You should also become familiar with your own tenant's limits. What are they allowed to do and what are they not allowed to do? Does your lease prohibit them, for example, from changing the locks? In many cases, tenants will come in and simply presume that they can control who can come in and out of the house, including excluding you, the landlord. Now, if you've got a keyless entry with maybe, a push button combination of numbers that gets you in, you definitely maintain more control of the premises. But if you've got an old-fashioned key and lock and they swap it out, you might be left out in the cold. Again, even if you absolutely need to get in, perhaps on an emergency basis, and this puts your property at risk. Make sure, if you are in a situation where your tenant has no right to change the locks, that you have not only just addressed that issue, but that you are familiar precisely with that limitation. What's in your lease? What's in your local jurisdiction in terms of a limit on what the tenant can do to exclude you from the property? If you've learned something new today, I'd like to hear all about it in the comments below. If you're just enjoying the video, give us a like. We appreciate that very much. And if you haven't subscribed yet, please consider subscribing. But moving along, if your tenant continues to violate your lease and in some way prevents you from coming in or excludes you entirely or demands something from you that the law does not require or that the lease does not require, then that's probably an appropriate time for you to begin issuing notice. Certainly if your tenant is in direct violation of your lease, you want to issue a written notice to the tenant indicating what portion of the lease they have violated. And what I recommend to landlords in these situations is if you've got to come in for an inspection or to complete a repair, that you send written notice to the tenant saying, on such and such date, I will be there in accordance with this section of the lease. Show up. If the tenant again prohibits you from coming in, let them know in a subsequent written notice, I was there before, I gave you notice on this date, I will come back on this future date. Your continued denial of my access, although I have access in accordance with this section of the lease, may result in an eviction. And by continuing this process until either you're able to get in or until you evict the tenant, you are setting the groundwork for a potential eviction, but also you're documenting each of these events so that if you're ever having to establish for the court why you took this position, or if you're later sued by the tenant with some accusation that you somehow violated the lease, you've at least got your written documentation in order so that you can present to any court. By knowing beforehand what your rights are and what the limits of the tenant are, and by being able to lay out a series of notices that you sent. I mean, if you just sent the one time and you try to evict them on that one basis, not very strong. I preach a 3 strikes and you're out rule. So minimally you should have 3 instances where you went and you were denied and you issued written notice each time. You want to be able to prove to any court that you understood your rights, that you attempted to exercise your rights, and the only reason you were unable to was because the tenant violated the lease and prohibited you from entering. And finally, it's not enough to just threaten eviction. If a tenant has violated your right to enter, has violated your right to complete repairs, or violated your right to inspect, then that's not a tenant you're going to want to keep. It's not enough to simply say, I may evict you. I strongly recommend that after 3 instances, you begin the eviction process and follow through with it. You may have a tenant who later says, fine, you can come in, but by that point, it's difficult for you to have confidence that this tenant will not continue to violate the lease or will not violate the lease in some other way, especially if this is early on in the process, which is precisely why I recommend right from the beginning that you have this discussion. Any indication by this tenant that they will be hostile to your right to enter is likely going to resurface later. So it's something you want to address early, and it's something that you want to squash early, even to the point of denying them the lease if this is such a big issue for them. By seeking the eviction, again, after multiple occasions, even early in the tenancy, you're likelier to protect your property and you're likelier to find a better fit, someone who will comply with your right to enter and inspect or enter and complete repairs over the course of the tenancy. Certainly someone who violates that right and is an impediment for you properly maintaining your property is ultimately going to cause immense harm to you, both economically and then ultimately to your property. Don't let the tenant monopolize how your property is cared for. The fact that they may, in their own opinion, be taking proper care of the unit doesn't necessarily mean that you can be excluded from it. The fact that they claim that they have a right to privacy, which is absolutely true, doesn't necessarily mean that they can deny you access to your right to inspect and maintain your rental property. I hope you found this particular video helpful to you. There's a ton of other content on this channel that I welcome you to watch. In fact, YouTube seems to think that this video right here is the next best thing that you should watch. And until next time, landlords, happy leasing.